Hello, everyone. In this lecture podcast, we deal with a Week 10 topic on the international powers of the Commonwealth. This topic, just like the other topics that we dealt with in the past, also involves the tension between the Commonwealth Parliament and the state parliaments, mainly because by using, for example, the power of the Commonwealth Parliament to legislate in relation to external affairs, oftentimes it then legislates on fields or subjects that would have exclusively belonged to the state parliaments. So that is one part of the tension that we will be examining in this lecture podcast. And in addition, what I'd like you to do is to think about some of these questions that I will propound for the purpose of having a better appreciation of the importance of this topic. So the first question we should think about is, would the defense power that is given to the Commonwealth Parliament enable it to pass a law dealing with domestic terrorism? Because typically when we speak of defense of the Commonwealth, we're obviously thinking of enemies from abroad. But would the defense power, for example, allow the Commonwealth Parliament to legislate on domestic terrorism or enemies from within? Secondly, the other interesting thing we need to think about is that in most jurisdictions, the retroactivity of criminal legislation is unconstitutional and impermissible. In other words, in most jurisdictions, such as the United States, for example, it would be unconstitutional for Congress to pass a law that would criminalize a behavior that at the time it was committed was actually valid. So criminal laws in the United States only must have prospective application. It would be unconstitutional for a criminal law to have retrospective effect or retroactive effect. And so the question that we need to think about is, do you think it would be valid for the Commonwealth Parliament using its, for example, its external affairs power to pass a law that would make an act that was otherwise legal at the time it was committed to become illegal? In other words, is it possible for the Commonwealth Parliament to validly pass a criminal law that is retrospective or retroactive in application? Related to that second question would be the question of whether or not the Commonwealth Parliament would have the power to criminalize behavior for acts or activities done abroad. So let's say you have Australians who travel to Thailand and they engage in sexual activities or sexual relations with children. Since the act occurred abroad, and obviously it is not within the territorial jurisdiction of Australia, would it be permissible for the Commonwealth Parliament to criminalize that kind of behavior? And the fourth question that I'd like you to think about is whether or not it would be legally permissible for the Commonwealth Parliament to pass a law using its external affairs power in the absence of a treaty. So typically what happens is that in the case of Australia, once a treaty has been entered into by the executive, the Commonwealth Parliament then, in order for that specific treaty to become part of Australian law, would pass a law that incorporates that specific treaty as part of Australian law. Now, what if, but in that regard, because on the basis of a treaty, it would then usually permit the Commonwealth Parliament to legislate on subjects that would have belonged exclusively to the state parliaments. So the question in this case is, let's assume there is no treaty. Would it be permissible for the Commonwealth Parliament to legislate on a subject that belongs exclusively to the states, even in the absence of a treaty? And the final question I'd like you to think about would be, would it be possible for Parliament to criminalize behavior done in Australia whose effects happen abroad? Okay, so these are some of the questions I'd like you to think about as we go through this lecture podcast, and we will in fact deal with these questions separately as we go on. So let's begin and go into the details of this lecture podcast. So in terms of objectives, after studying this topic, you should be able to discuss and explain how the Commonwealth Parliament, by using its international powers, particularly relating to defense and external affairs, is able to expand its reach into areas usually associated with state parliamentary powers. And then you should also be able to discuss and explain how the Commonwealth Parliament, by using its external affairs power, is able to legislate on matters outside of and external to Australia. So let's begin with the defense power. So the defense power is found in Section 51, subsection 6, which provides that the Commonwealth Parliament shall have power to make laws with respect to the naval and military defense of the Commonwealth and of the several states. In the case of Australian Communist Party versus Commonwealth, or the Communist Party case, Justice Fullagar identified two aspects of the defense power. The first aspect, which was the primary aspect, is the power of the Commonwealth Parliament during times of war and peace to pass laws which has the defense of the Commonwealth and the states as its direct and immediate object. So the legislation, therefore, would relate to those matters which have as its object the direct and immediate object, the defense of the Commonwealth and the states. But that specific power as well has a secondary aspect, and that is, it is expansive in the sense that it authorizes the Commonwealth Parliament to pass laws even if they do not have as its direct and immediate object the defense of the Commonwealth or the states, but in fact relate to non-defense matters, such as, for example, food, clothing, or housing, or even concerning financial, economic, and social conditions. That is a secondary aspect. So we will examine these two parts of the defense power in a short while. So let's just first begin with the primary aspect. So if you look at the primary aspect, this would involve, for example, the conscription of citizens of Australia to join the defense force. It could also be the compulsory use of certain factories as vehicles for the production or manufacturing of weapons or materials that are important in the defense of the Commonwealth and the states. So that these would constitute some examples of the primary aspects of the defense power, which has for its direct and immediate object the defense of the Commonwealth and the states. But the secondary aspect can touch upon such matters as the control of prices or rent and employment. So during times of war, using the defense power of the Commonwealth Parliament, it would be permissible for the Commonwealth Parliament to control prices, to control rent, and to regulate employment. Even if, when you think about it, these subjects are not directly and immediately linked to the defense of the Commonwealth and of the states. But because it is important for the Commonwealth Parliament to be given a wider latitude during times of war to regulate and control activities within the borders of Australia, the High Court recognizes the validity of Commonwealth legislation that seeks to control prices, rent, and even regulate employment. It was also through the defense power that the Commonwealth Parliament was able to wrest exclusive control over income taxation, and this was validated by the High Court in the case of South Australia versus the Commonwealth in the first uniform tax case. It would even be permissible for the Commonwealth Parliament to control the production of bread. In other words, it can even say who can produce bread, who can bake bread, and so on. And this was the case involving Stenhouse versus Coleman, where Stenhouse was charged for producing bread in the absence of a license. And you would think, that seems to be quite unreasonable. But the High Court, in fact, validated the regulations based on an enacting legislation from the Commonwealth Parliament that regulated who could control, regulated who could produce and bake bread. And so the conviction, therefore, of Stenhouse in this case was actually validated and affirmed by the High Court. Now, when we think, we have to go back to the expansionary consequences of the engineer's case. And we will remember that under the engineer's case, the High Court ruled that it was unwilling to read any implied limitation on the Commonwealth Parliament's power to legislate under the heads of power of Section 51. So what it means is that for as long as a specific subject was within a head of power of the Commonwealth Parliament, in other words, it was within the power of the Commonwealth Parliament to legislate on a specific subject, it would then be possible for the Commonwealth Parliament to legislate on a related subject, even if that subject appears quite remote. So, for example, if the Commonwealth Parliament, for example, passes a law relating to trade and commerce among states or concerning exports, for example, the Commonwealth Parliament in the same law can have a provision concerning the construction of highways and roads, which fields actually belong to the state parliaments, or in the process of the Commonwealth Parliament legislating, for example, on let's say fisheries in Australian waters beyond territorial limits, the Commonwealth Parliament may, in the same process, also legislate in relation to the environment, which again would be a field that is exclusive to the state parliament. So that is the expansionary consequence of the engineer's case. So that for as long as the Commonwealth, for as long as the law that the Commonwealth Parliament passed is within its power to legislate, for example, under Section 51, the fact alone that that same law includes a subject that should have exclusively belonged to the state parliament will not invalidate that law. Even if the subject over which the Commonwealth Parliament legislated on is quite remote from the subject over which the Commonwealth Parliament constitutionally has the power to legislate on, that still will not be a basis to challenge the constitutionality of that law. So that is the expansive effect of the engineer's case. So the High Court in that case had used a literal approach in the interpretation of the Australian Constitution. And so the question that arises here would be, would it be possible for the Australian Commonwealth Parliament, for example, using its defense power to then, for example, legislate in relation to education or to legislate in relation to corporations? So that is the question. Can the expansive effect of the engineer's case be used to enable the Commonwealth Parliament to use its defense power to legislate on matters that are not really directly related to the defense of the Commonwealth? That is the question. And the thing we have to remember is that The Section 51 concerning the defense of the Commonwealth, means Section 51, subsection 6, is peculiar and is different from the other heads of power under Section 51, because most of the other heads of power would usually refer to a class of legal, commercial, economic, or social transactions or activities. For example, trade and commerce, or banking and marriage. Or it could specify some class of public service, for example, postal installations and lighthouses. Or it could relate to the undertaking or an operation, such as the railway construction with the consent of a state. Or it could involve a category of legislation, such as bankruptcy or taxation. However, when it comes to the defense power of the Commonwealth, it is different, because when you speak about the defense of the Commonwealth, defense, it means there is a purpose. The purpose of a law has to be for the defense of the Commonwealth. So the High Court in Stenhouse versus Coleman, for example, clearly indicated that there is a purposive test that must be applied when the defense power of the Commonwealth Parliament is being used. So in other words, there must be a factual link between the defense and the law. So in other words, it would be impermissible for the Commonwealth Parliament, using its defense powers, to then legislate in relation to education. So just to repeat for emphasis, whereas in the engineer's case, it would have been permissible, or it is permissible, for the Commonwealth Parliament, by using its trade and commerce power with other countries, to then legislate in relation to education, or to then legislate in relation to sole proprietorships, or to then legislate in relation to hospitals, or in relation to the construction of roads. But in relation to the defense power of the Commonwealth Parliament, it is crucial that when a law is passed under the defense power of the Commonwealth Parliament, that law must be able to show that its purpose is for the defense of the Commonwealth. Otherwise, that law will be invalidated. So a purposive test is applied. As Justice Dixon said in Stenhouse versus Coleman, a law with respect to the defense of the Commonwealth is an expression which seems rather to treat defense or war as the purpose to which the legislation must be addressed. However it may be expressed, whether by the words scope, object, pith, substance, effect, or operation, the connection of the regulation with defense can scarcely be other than purposive if it is within the power. So if a law has been passed under the defense power, that law must be able to show that its purpose is for the defense of the Commonwealth and the states. But the other limiting effect that the High Court has imposed as far as the defense power is concerned is that it has also required a sufficient connection between the purpose and the law, as well as an issue of proportionality. Let's begin with the first one, sufficient connection between the purpose, meaning it should be for the defense, and the law. So in the case, for example, of R versus University of Sydney ex parte Drummond, the Commonwealth Parliament set limits on university student admission numbers, and it invalidated, the High Court invalidated that specific legislation because it couldn't see a sufficient connection to national defense objectives. They couldn't see what limitations on university student admission numbers had to do with achieving national defense objectives. So that law was invalidated. In the case of Victorian Chamber of Manufacturers versus Commonwealth, or the industrial lighting case, the Commonwealth Parliament passed a law that set lighting standards for industrial premises. Again, the High Court invalidated that legislation because it couldn't see any specific relation to the subject of defense, except insofar as all matters affecting the well-being of the community have such relation. So that law again was invalidated. And in the case of Adelaide Company of Jehovah's Witnesses Incorporated versus Commonwealth, or the Jehovah's Witnesses case, the Commonwealth Parliament passed a law which authorized the seizure of Jehovah's Witnesses property and the prohibition of the publication of their doctrines as being beyond. The High Court ruled that it was beyond the power of the Commonwealth to pass this legislation because it was overly broad. Now remember, these three cases occurred during World War II, so it was during wartime. And yet, notwithstanding the fact that these pieces of legislation were passed during times of war of Australia, they were still struck down for being unconstitutional. Because in the first two cases of our University of Sydney and Victorian Chamber of Manufacturers versus Commonwealth, the High Court couldn't see a sufficient connection between the law and their purpose being for defense. And in the case of the Jehovah's Witnesses case, the High Court ruled that the law, even if it was meant to be for the purpose of the defense of the Commonwealth, the law was not in proportion to the kind of measures that were implemented for the purpose of promoting the defense of the Commonwealth and to the states. In the case of Australian Communist Party versus the Commonwealth, or the Communist Party case, Justice Williams also said that the extent to which it can entrench upon these rights is limited by the reasonable necessities of defense during the period of war. So in other words, again, it is crucial that when the defense power of the Commonwealth is cited as the basis for the Commonwealth Parliament to legislate, there must also be a showing not only of proportionality, but of the reasonableness of that law in relation to its goal or its purpose of achieving the defense of the Commonwealth. Now, so we've initially spoken of the defense power as relating to the defense of the Commonwealth and the states against external threats. But the question arises whether or not the defense power can actually be used to address internal threats such as domestic terrorism. And this is important because we will remember a few months back, there was a problem in Sydney of Monies who ended up taking hostage some of the customers and employees in the Lynn Cafe. So the question is, can the defense power be used for the purpose of dealing with internal threats? And the answer is yes. In the case of Thomas versus Mowbray, the High Court ruled that it was permissible for the Commonwealth Parliament to use the defense power to legislate in relation to internal threats. So in that case, the High Court recognized as valid the law that imposed constraints on Thomas in terms of imposing a curfew upon him, limitations upon his movements, as well as limitations on his ability to communicate with other people or even use technologies. And those limitations on the rights of Thomas were recognized as being valid under the defense power of the Commonwealth, even if in that case the defense power was used in relation to internal threats and not directly external threats. So we've already talked just now about that aspect of the international power of the Commonwealth Parliament, which related to the defense power. The other aspect of the international power relates to the external affairs power of the Commonwealth, and this is provided by Section 51, subsection 29 of the Australian Constitution. Now, this specific provision has often been used by the Commonwealth Parliament to legislate on matters that exclusively belonged to the Australian parliaments. So the Commonwealth Parliament therefore has used it as a way to encroach into areas or fields that under the Constitution belonged exclusively to the state parliaments. And that's why it's crucial to look into this. And obviously the external affairs power has been used by the Commonwealth Parliament to legislate on matters which are external to Australia. So there are three aspects to the external affairs power. One is the geographical power over matters which are external to Australia. The second aspect relates to the treaty power over matters covered by legislation in the implementation of treaty obligations. And thirdly, it relates to the international relations power. And we will discuss these aspects individually in a short while. So let's begin with the first aspect of the external affairs power, which is the geographical power. And we will go back to the question that I initially posed in the introduction of this lecture podcast. The first question that I asked was, can Parliament criminalize behavior of Australians that are done abroad? So the example I gave was, would it be permissible for the Commonwealth Parliament to pass a law that would criminalize the act of engaging with children in sexual relations abroad? Or perhaps the counterfeiting by Australians of foreign currency abroad? Or would it be permissible for the Australian Commonwealth Parliament to pass a law criminalizing the act, for example, of engaging in drug trafficking abroad, even if it doesn't really happen in Australia? So that's the first question. The second question is, would it be valid for the Commonwealth Parliament to make a criminal law retrospective in application? What this means is that, would it be possible for the Commonwealth Parliament to pass a law that criminalizes an act which at the time it was committed was actually valid, assuming that that act happened outside of Australia? And the answer to both questions is yes. So in the first instance, using the external affairs power of the Commonwealth Parliament, it is permissible for the Commonwealth Parliament to criminalize behavior of Australians for acts that they do abroad, using the external affairs power. So it can pass legislation that would make it a criminal act for Australians to, for example, engage in sexual relations with children abroad, or to do acts of bestiality abroad, or to engage in human trafficking abroad. It would be legally permissible for the Commonwealth Parliament to legislate in that regard. This is also based on the ruling of the High Court in Polukovich versus the Commonwealth. And that specific case also provides the answer to the second question that I posed in relation to whether or not it is legally permissible for the Commonwealth Parliament to pass a law that has a retroactive effect. Now, we must remember that in most jurisdictions abroad, in the United States, for example, or in the Philippines, in their constitutions, it provides that no criminal law shall have any retroactive effect. So that is because it seems to be against norms of conduct and human decency, why something that was initially legal should then become criminal because of a law that was subsequently passed. So in most jurisdictions, there's a law which provides that ex post facto legislation or laws with retroactive effect are unconstitutional and impermissible. Now the question is, does that state of affairs also apply in Australia? And the answer is no. In Polukovich versus Commonwealth, this involved the case of Polukovich, who was accused of committing war crimes during World War II. So particularly in the period of 1943 and 1944. So Polyukhovich was accused of having committed war crimes in Eastern Europe. So the acts happened in Eastern Europe, not in Australia. At the time that it happened, Polyukhovich was not an Australian subject. He was not an Australian citizen. He, in fact, lived in Eastern Europe. But he was accused of committing war crimes. At the time that he committed these so-called war crimes, they were not crimes in Australia. So the only time they became crimes in Australia was when the law was passed, criminalizing war crimes. So that happened almost 50 years after the acts of Polyukhovich were committed. The High Court ruled that it was valid for the Commonwealth Parliament to pass that retroactive criminal law under the external affairs power of the Commonwealth. And in particular, the High Court ruled that unlike the United States Constitution, for example, where there is an express prohibition against the retroactive application of criminal laws in its Bill of Rights, the Australian Constitution does not have a Bill of Rights, which is a subject we're dealing with in the next lecture podcast. And in the absence of a Bill of Rights, the High Court was not prepared to consider that there is an implicit guarantee of the non-retroactivity of criminal laws in the Australian Constitution, because it was absent. So in that case, therefore, the High Court ruled that it was legally permissible for the Australian Commonwealth Parliament to criminalize an act that at the time it was committed was actually legal. But again, we must remember that there is a gloss on this specific case, because we're talking of war crimes or crimes against humanity, which involves the utter dissatisfaction and the abhorrence of the international community towards war crimes. And it begs the question of whether or not the High Court would actually tolerate a criminal law that has a retroactive effect if it involves a crime committed in outside of Australia, but it would be over a petty matter such as theft, or for example, slander, or maybe murder. It's possible that the High Court will say no to that kind of retroactive application of a criminal law. So Polyukhovich versus Commonwealth is important still, but we just have to remember that it was in relation to a war crime or a crime against humanity, which is considered to be the subject of universal condemnation by the rest of the world. Now, the other aspect of the external affairs power relates to the treaty power. Let's begin with by talking about what a treaty is. So a treaty is an international agreement that two states at least enter into. And in that case, in relation to Australia, or in most countries for that matter, the process of entering into a treaty is conducted by the executive. So it is not a matter that is for the Commonwealth, that is for the a parliament to deal with. So it is a purely executive function. And the courts have recognized that as far as the power of the executive to enter treaties into is concerned, there is practically no limit, except for those where the Constitution will probably disallow it or prohibit it. But otherwise, the executive has broad powers to determine what treaties to enter into. So now, the thing is, even if the executive, whether the prime minister, for example, or the defense minister or the foreign minister, enters into a treaty with another state, assuming that that treaty has been entered into, let's say by Australia through the Australian executive, that treaty does not become a part of the law of Australia. So let's be clear about that. So under Australian law, even if a treaty is entered into by the executive, and therefore it becomes a source of binding obligations in a sense, that treaty still does not become part of the law of Australia until the Parliament passes an enabling law that adopts that treaty. So we have what is known as the incorporation approach. So that the only time that a treaty becomes part of Australian law is when that treaty has been incorporated in domestic legislation that has been passed by the Parliament. It's also important to note that while the executive has very broad powers to determine what treaties it wants to enter into, and so therefore the executive therefore can obviously enter into treaties involving fields or subjects that belong exclusively to the state parliament. So it can enter into a treaty concerning mining or the education or the environment and so on. The Commonwealth Parliament has the power to refuse to adopt any treaty. So the Commonwealth Parliament can refuse to pass an enabling law or a law that would incorporate a treaty as part of domestic law of Australia. And that is the clear ruling of the court in Quarta versus Jelk versus Peterson. Now, the key point here that needs to be emphasized is that what has often happened is that when the Commonwealth, when the Commonwealth executive enters into a treaty, so let's say the treaty is on the environment, which, as we said, is a subject which exclusively belongs to the state parliaments. On the basis of that treaty, once the Commonwealth Parliament then incorporates that treaty as part of Australian law, it then enables the Commonwealth Parliament to legislate in relation to a field or subject that would have belonged exclusively to the state parliaments. And what it also means is that on the basis of that treaty, the Commonwealth Parliament can also touch on matters that are purely internal. It also means that it would be permissible for the Commonwealth Parliament using the treaty to legislate on areas that were not actually fully contemplated by a treaty obligation. Now, however, the High Court in the Commonwealth versus Tasmania case, or the Tasmanian Dam case, has pointed out that still there must be a reasonable proportionality between the designated purpose or object and the means which the law embodies for achieving or procuring it. Now, the third aspect of the internal affairs power relates to the internal relations power. This is different because as far as the international relations power is concerned, this does not really focus on the treaty power or the entering into of treaties. It more or less refers to the relationship of Australia with other nations. And so the question being that we should propound is, can the Commonwealth Parliament criminalize behavior done in Australia whose effects happen abroad? And so in the case of R versus Sharkey, the High Court ruled that in the case here where Sharkey, where the Commonwealth Parliament passed legislation that made it criminal for any person in Australia to make seditious statements or seditious publications against the UK, Imperial UK, the High Court ruled that that specific law was valid as part of the international relations power of the Commonwealth Parliament, whose purpose was to preserve Australia's relationships with other nations. Now, how do we distinguish R versus Sharkey from Polyukovich versus Commonwealth? I should just remind you that as far as the case of Polyukovich versus Commonwealth was concerned, when the Commonwealth Parliament passed a law that criminalized war crimes that were committed during World War II, there was no treaty that Australia entered into. So this was just a law that the Australian Commonwealth Parliament passed on its own. So going back, how do we distinguish R versus Sharkey from Polyukovich versus Commonwealth? So in the case of R versus Sharkey, the Commonwealth Parliament passed a law for the purpose of ensuring that Australia is able to preserve its relations with other nations. So it was as a result of Committee of Nations, or good relations with other nations. In relation to Polyukovich versus Commonwealth, it wasn't, there was no need for Australia to try to come up with a good image and for the purpose of enhancing its relationship with other nations by criminalizing war crimes that were committed during World War II. So in that case, as far as Polyukovich versus Commonwealth was concerned, it was mainly based on the geographical power of the external affairs power of the Commonwealth that was used, in the sense that the act that was criminalized was an act committed outside of Australia or external to Australia, and therefore on the basis of the geographical power of the Commonwealth Parliament, it was permissible for the Commonwealth Parliament to pass a criminal law that had a retroactive effect to criminalize behavior that occurred outside of Australia, even if it happened during World War II. In the case of R versus Sharkey, this related to an act that was committed within Australia, but whose effect could be external, in the sense that it could damage the relations of Australia with the UK Parliament, for example. And so therefore, for that reason, the High Court also ruled that that law was valid. Now, the final question that we ask is, as we said, typically what happens is that the Commonwealth Parliament passes a law that incorporates a treaty. And in that case, assuming that the treaty, for example, relates to the environment, the Commonwealth Parliament would then try to pass legislation that goes beyond the subject of environment, and may, for example, pass legislation concerning education. And the High Court has tolerated this and recognized that it is valid. Now the question is, what if there is no treaty in the first place? Would it be permissible for the Commonwealth Parliament to then pass a law that encroaches on a subject or field that under the Constitution belongs exclusively to the state parliaments? And the answer is yes, if the subject on which the Commonwealth Parliament legislated on is of an international concern. In other words, it is a concern recognized by most of the nations or by the international community. So even if there is no treaty, but the subject or field is one that is of an international concern to the community of nations or to most nations, and that can pertain, for example, to climate change or environmental degradation, it would be permissible for the Commonwealth Parliament to pass a law, even in the absence of a treaty, focusing, for example, on climate change or environmental degradation, and in the process, legislate on fields that are a bit remote to climate change or environmental degradation. And this was the ruling of the High Court in Richardson versus Forestry Commission. So after studying this topic, you should be able to discuss and explain how the Commonwealth Parliament, by using its international powers, particularly relating to defense and external affairs, is able to expand its reach into areas usually associated with state parliamentary powers. And then discuss and explain how the Commonwealth Parliament, by using its external affairs power, is able to legislate on matters outside of and external to Australia.